Right. Soundtrack.
Hello, everyone. My name is Mackenzie Bretz, and today I'm going to be talking about some tips for filing a comprehensive civil protection order. See if I can get my PowerPoint to work here. Alrighty. All right. So one of the first questions we sometimes encounter is why would a person file a civil protection order versus something criminal? There's many different reasons for this. I'll just kind of review some of them. Um, Firstly, there are some situations where, you may feel unsafe or uncomfortable, but police is not willing to step in or do anything. They don't see a violation there. So this is a point where you could file a civil protection order for your safety. There's also instances where the police are seeking further criminal action, but in that time where your information is sent to the prosecutor, you still feel the need to be protected. And so a civil protection order helps in the in-between time. Um, there's a lower standard of evidence for civil protection orders, so that can be helpful. Rules of evidence don't apply as stringently in civil protection orders. Um, Another common reason is sometimes parties, you know, have experienced violence or domestic violence in the past and it was never reported. And then they have another instance of something happening. And that is kind of their breaking point, and they finally feel the need to file for a protection order. So these instances in the past, while they might not be a basis for a criminal prosecution, they could, be a basis for your civil protection order. So those are just some of the reasons. So first, I'm going to kind of go through the different types of protection orders, and then lastly, I'll talk about some tips if you're filing yourself or if you're seeking an attorney to file some of these things to look out for, things to get prepared for, and ways to make your protection order really effective and easily readable by the court. So some of the different most common types of protection orders are a domestic violence protection order, sexual assault protection order, anti-harassment protection order, stalking protection order, extreme risk protection order, and vulnerable adult protection order. So these are not all of them, but these are the most common types of protection orders. So first, starting out with the domestic violence protection order. This type of protection order can be brought against an intimate partner or a family or household member. So intimate partner typically means boyfriend, girlfriend, husband, wife, or someone you've been having intimate relations with. A family or household member, this could mean a lot of different things. Mom, dad, sister, brother, stepmother, stepfather, mother-in-law, father-in-law. And then if you're living with roommates, they could also be included in this. A domestic violence order seeks to protect from violence or a threat of violence. Or coercive control. So coercive control is a new part of the domestic violence protection order law that was enacted last year, I believe. And it is a lot of things that were long considered domestic violence, but they have now been codified in law. So we're talking about things such as damaging property, using technology to threaten or harass, intimidation, which comes in many different forms, carrying, exhibiting, or displaying a firearm in a way to threaten or harass, driving recklessly with you or a minor child in the car, um, harming people's career, threatening suicide, causing dependence, confinement, or isolation. These are just some of the issues of coercive control. This list is far more extensive, and the legislator has said that this is not an exclusive list, but coercive control is a new way that domestic violence is being recognized for survivors. Um, if you're seeking to file a domestic violence protection order, you can also seek to protect any minors who are either your children or live in the home with you. So if you're sexually assaulted, harassed, or stalked by an intimate partner, um, you should likely be seeking a domestic violence protection order. It's not required, but this is an order that's likely going to protect you best. There is this little chart that is on Snohomish County's website, kind of helping you to figure out maybe what type of protection order you should file. As you can see in the top right corner, it says, is the respondent's relationship to you household or family member or current or former dating relationship? Sorry, the first question is, has the respondent sexually assaulted you? Next is, do they fall under that category that we just talked about in the domestic violence protection order? If they do, then you should file a domestic violence protection order. If they don't, then you should file a sexual assault protection order. So next, that's what we're going to talk about, sexual assault protection order. This is protecting against non-consensual sexual touching or penetration, even if the conduct occurred only once. Next, we have an anti-harassment protection order. This is protecting against unwanted contact or behavior that causes emotional distress and serves no lawful purpose. It is helpful in these type of cases if you are being what you think is harassed by a person, to firmly and succinctly state in writing is best, that you no longer want their contact, that you have asked for them to stop. And if they continue, it gives you stronger evidence in your case that they are further harassing you. However, like it says here, it could be a pattern, a single act, or a threat of violence. So it doesn't have to be consistent, but this just helps in your case if you have that. The contact must be specifically targeted at the protected person. So they have to be harassing. If I'm the one filing an anti-harassment order, excuse me, the contact has to be directed at me. It can't be directed at someone else, and I feel that the other person is getting harassed. The conduct must be alarming, annoying, harassing, or detrimental. Many of you may say, you know, my version of alarming or annoying may be very different from someone else's. One case included numerous instances of profane sexual proposals, discriminatory rhetoric, physical intimidation, and threats to kill, right? So these obviously escalated, but it started out with kind of small things that the court still saw as harassment. Next is a stalking protection order. This is protecting from behavior that serves no lawful purpose and reasonably causes a person to feel intimidated, frightened, underdressed, significantly disrupted, or threatened. So the important part of, you know, this line here is reasonably causes a person. So this is behavior that, if done to any other person, would reasonably cause someone to feel these feelings. That the person should have known that the behavior causes these feelings, even if it is their not intent. So this kind of means that, you know, this behavior is known to be inappropriate. Also, I think where you'll run into some trouble is if you have potentially a person with developmental disabilities, or someone who can argue that they didn't know that their behavior was inappropriate, then that might cause an issue in this stalking protection order, because they have to know or should have known their behavior it was wrong. This can include cyber harassment, surveilling, or monitoring. Courts have, you know, in the recent years become more up to date with how a person can really be targeted over social media, over online platforms. So this is definitely can be under a stalking protection order. Extreme risk protection order. So this really has more to do with restraining someone from possessing or purchasing a firearm. You would bring this in an instant where you had an encounter with someone or someone was really threatening to use a firearm on someone else or on themselves. In domestic violence protection orders, you can ask for a restriction of firearms. This order is a little less common, but if you have a specific instance involving a firearm or involving someone's use of it, this may be the better route to go. Vulnerable adult protection order. So this is helping protect a vulnerable adult who has been abandoned, abused, financially exploited, neglected, or threatened with these things. Typically, someone else is bringing this on behalf of a vulnerable adult because a vulnerable adult is typically not bringing this themselves. A vulnerable adult is defined as someone who can be described as 60 or older, has the functional, mental, or physical incapability to care for him or herself. So this is typically when, typical cases of this is we see someone who, has a health condition, who is maybe living in a home and, either a family member or someone of a similar relationship is maybe spending the vulnerable adult's money or, using the vulnerable adult's medical condition against them in some way. So next we're going to go into kind of some tips and tricks. So you must plead the specifics in your motion for a protective order. This may seem obvious, but I think often when we're filing protection orders, they're very emotionally charged. And we want to say every single thing we can think of. And sometimes it can be overwhelming to the court. But I think when you're bringing a protection order for any of these issues, you should really look at for a domestic violence protection order, what are the threats of violence? What are the issues of coercive control? What are the issues of violence? And specifically lay those out to the court. On my side here, it says if you're bringing a stalking protection order, demonstrate how their actions have no lawful purpose, how not only you, but a reasonable person would feel intimidated or scared. And again, I think sometimes we get caught up in the emotional aspects of our cases and say, this should be obvious to everyone. This is harmful. This is domestic violence. And sometimes it helps a court to, if you can break this down more specifically for them to really see the issues as you're laying them out. Evidence, of course, I completely understand a lot of these cases, you don't have evidence, right? You don't have photos, you don't have the physical harm anymore. Maybe time has passed. You don't have texts, you don't have emails, right? A lot of the time that does happen. But if you do have anything, it is helpful to present it to the court. So some ideas of things you can bring are, if a person has called you 75 times, right? A screenshot of your phone log. If you have harassing text messages, those are helpful. It is also very helpful to be able to organize those in a positive way for the court to show dates of when the messages are sent, to make sure the parties are labeled so the court can understand who's sending what message, right? Think when we present evidence, we know what it is. And so we present it sometimes as it is, but it's often helpful to be over-explanatory so that the commissioner or the presiding judge knows what you're talking about. Photos of your injuries or damages to your home, your vehicle, ring videos, police reports. Police reports often take a lot of time to get. So if you're thinking of filing a protection order, that should be something you're seeking a request from right away. Each county has different page limits, so make sure you're aware of that. Some counties include exhibits or evidence as your page number, some don't. So make sure you're kind of aware of those issues. Organization, I talked about that a little bit, but make sure things have page numbers, make sure things are labeled. Even your sections talking about different issues in your case, label those, right? Think about a commissioner or a judge looking at this for the first time and how can you make it the most easily accessible for them. Some orders may grant further relief. So in a domestic violence protection order, if you are married to a person or living with a person, you can ask for possession of a home, possession of a vehicle, for finances to remain the same. And we have a photo of a dog on here because you can ask for a possession of animals. So those are some things you can see as well. Length of orders. So when you initially file your protection order, if the court agrees with you, they'll give you a 14-day temporary order. The 14 days is until your next hearing on the matter. And then if your protection order is granted, courts will typically grant a year order. You can seek for longer than a year. However, from my experience, this is a little bit unlikely, especially if there's children involved. The court doesn't want to grant anything longer than a year, but it is not unheard of. What happens if there's a violation of your order? So you've gone through all these steps, you filed a protection order, it's been entered in the court, and the opposing party violates this order. This is generally a gross misdemeanor, so punishable by 364 days in jail, a fine up to $5,000 or both. It could be a Class C felony if there's more violence involved. This should be definitely something, that is reported to the police immediately. And this is the end of my slideshow. If you have any further questions or you're seeking to file your own protection order, please feel free to reach out to me. This is my email and the phone number. And thank you so much. Have a great day.